Welcome to this lecture review on e-discovery and Introduction to Digital Evidence. Here we're looking at Chapter 2, A Brief History of E-Discovery. So, the point of this chapter is to describe the origins of e-discovery, define types of metadata, describe e-discovery from a civil and criminal perspective, using the FERCA legal analysis method to read a case, and we're going to end with understanding the electronic discovery reference model. Right, so, when did e-discovery begin? The term e-discovery, again, is fairly new. The field it represents has been around for several decades. As long as we've had electronic storage, we've been able to look at electronic review, or electronic discovery. Storage media available today was not available decades ago, hence the evolution of our storage. With that, evidence was represented in the forms of rearms of computer printouts, or reams. Stacks of paper intimidated opponents, where we don't have that anymore. We can have a 100-page report as an electronic document. It's not as intimidating. We have to understand a few very important acts and laws. The big one is the CFAA, or the Computer Fraud and Abuse Act, created to address the problem of computers being hacked. Before this, the Counterfeit Access Device and Abuse Act of 1984 targeted fraud and computer crime. However, U.S. Congress adopted the CFAA Act in 1986 as an amendment to that act. Computer abuse is defined as the illegal use of computers or related services to distill or modify data. That is the definition that we're going to be using throughout this book about computer abuse. Part of the National Information Infrastructure Protection, NIIP Act of 1996, it was working as added to the Computer Fraud and Abuse Act to cover extortion and threatening harm to protected computer. Additional changes were made in 2001 and 2006 with the Patriot Act. The Entity Enforcement and Restitution Act of 2008 made an amendment to the CFAA allowing prosecution if the victim and predator are in the same state. Allows victims of identity theft to seek restitution. Early mainframes were designed to be accessed remotely via an open source or open secure protocol like Telnet or FTP, where the data is not encrypted. It's not designed to be secured. So most network administrators now disable these services because they are not secure. We had what's called the CERT, Computer Emergency and Response Team, at one of the major universities, has estimated computer intrusions have increased about 500% between 91 and 94. Again, that's kind of dated. That's over 20 years old. A better question is how much has it increased now in 2016, 17, and 2018? Stats from 20 years ago, 23 years ago, does us no good. I'm sorry. Alright, it doesn't want to go to the next slide. There we go. In early days of the internet, hackers broke into networks just to show they could. They still do that now, but it's more the hackers are becoming younger and younger. These arguments led to the passing of the CFAA because we need to be able to protect a computer. Because if we're looking at a financial computer or a financial institution or a government agency that uses these devices, they must be protected. They must be secured. Hence, the CFAA. 7 types of computer offenses covered by the CAA: accessing a computer or network without authorization or by exceeding authorization, 1. Accessing a computer or network to collect financial, credit, or other information from a government or protected computer, 2. Making a computer or network unavailable for its intended use, 3. transmitting programs, information, codes, or commands to intentionally cause harm or damage to the network or computers. 4. Access information on a computer or network to commit fraud or to cause damage. 5. Intentionally obtain and traffic in passwords. 6. And lastly, threatening harm to a computer or network for use of extortion or similar practices. 7. Here we have a short timeline. At CFAA 97, we use the term e-discovery, Patriot Act, things like SOX and HIPAA, and 2006, e-discovery goes more mainstream. We have electronic data interchange, which was created in the 70s to exchange information electronically easier. We have what's called a value-added network, or a VAN, which is a third-party service providers that create for transferring EDI documents between companies, similar to ISPs. The purpose here was to automate business transactions, such as purchase orders, requests for proposal, invoices, and packing slips. If you look at modern-day e-commerce, that's why we have our EDIs, so that we can more seamlessly transfer information, payments, purchasing, invoices, better. EDI became the model for doing businesses on a global scale. The United Nations Electronic Data Interchange for Administration, Commercial and Transport, Commerce, not commercial, commerce, UN EDIF ACT, too many acronyms, is a collection of international guidelines for exchanging electronic information so we can do purchasing globally. SOX and HIPAA are compliances that require companies to keep accurate track of electronic documents. SOX requires publicly held corporations to hold on to emails for 5 years and be able to turn over data when requested by courts, while HIPAA protects health, protects patients' medical history, and specifies other privacy rights. Moving on, the first discussion in a major law journal of e-discovery being used is civil litigation, appeared in 97. E-discovery became a more popular topic in civil litigation discussions around 2001. Metadata, or Metadata Encoding and Transmission Standards, METS, is the standard for use for objects in digital libraries. Developed by the Digital Library Association and maintained by the Library of Congress, METS profiles are found in PDF files, photography, photographs, CDs, and other digital records. METS has 5 categories of metadata: descriptive metadata, administrative metadata, file objects or file groups, structural maps, and behavior. File groups would be things like the electronic versions of a file, such as a TIFF, a PDF, etc. Administrative metadata describes how a document was created and stored, the original source object, and intellectual property rights. Descriptive metadata lists the metadata embedded in the document or external descriptive metadata stored on the internet server. OS metadata is what is stored by the computer and the network operating systems. Typically, the OS will keep track of things like the MAC times and dates, created, accessed, controlled, shows when the data was modified, accessed, and created, MAC being modified, accessed, and created. Both an OS and network operating system can show investigators the last time a file was accessed, whose login was used to modify the data, and material and such. In civil cases, only the metadata embedded in the documents is captured, not the OS or network operating system metadata. So depending on the type of case, it can vary what you're allowed to access. Metadata is used mainly for organizing the discovery process. Content of the documents and emails is more important than the metadata depending on the case. So things like deleted information might be deemed not readily accessible or too costly to retrieve. Keep that in mind. It is most likely not producible. What's used in e-discovery is metadata embedded in documents, which stores information such as the author and application used to create it. Some of this is subjective. Deleted information might be deemed, not necessarily is deemed, depending on the organization working on this. For perspective affects how people approach e-discovery. The legal professional understands the law. The e-discovery professional comes from more of a corporate background. The digital forensics understands the forensic standards, software, and procedures. And then we have the IT professional who knows where the information and files are stored and might have more limited knowledge of what's legally accessible. For criminal e-discovery, we have certain trends to focus on digital forensics. This is known as computer forensics. OS metadata is analyzed to identify things like evidence, alterations, and user activities. This can also deal with embedded document metadata to help organizations use that as a case-by-case basis. This is used to establish a timeline in order to corroborate people's location and determine who had access and if they were reasonably protected. Who had access and who actually accessed them. Again, if we're talking criminal, we're looking at computer forensics. It's also assuming that we're dealing with a computer. We have a few federal rules as it deals with criminal procedures, FRCRP, and that's especially Rule 41, which is dealing with search and seizure. Rule 41 specifies how to get and carry out a search warrant. It explains the motions to suppress evidence and how evidence must be returned. Rule 41 ties directly to the Fourth Amendment, and it does protect the rights of residents for unreasonable search and seizure. Again, most of this you're going to be consulting with your law expert before doing any of this, because again, the forensics expert may not be an expert in law. Search and seizure laws help ensure that volatile electronic evidence isn't compromised. I don't really agree with that, but there's a structure behind what the author is trying to say. That the search and seizure laws are set up in such a way where we should be able to do our forensics investigation on a computer to help minimize loss or risk. Investigators work with the network administrators to view network logs. They can also determine who is logged in and at what time, and that's assuming that we're doing this in a corporate environment. They also talk to physical staff to find out information. Example, whose key card was used to get into the restricted area, as example. Digital forensics and e-discovery have different paths to securing evidence. While e-discovery, investigators already know where the data is located, digital forensics focus on the hardware, operating system, network devices. In addition to the data mining, forensic technicians look for deleted files, deleted emails, hidden portions. They also may look at RAM and other data storage possibilities. So e-discovery is not as search heavy, where digital forensics may be. E-discovery from a civil perspective, e-discovery is more common in civil cases. Civil attorneys tend to be more aware of the FRCP, federal rules for civil procedures. The following states do not have specific rules, like things like Alabama, I can talk tonight, Colorado, Delaware, Florida, Georgia, Hawaii, Kentucky, Missouri, New Mexico, Nevada, Oklahoma, Oregon, Pennsylvania, Rhode Island, South Carolina, South Dakota, Vermont, Washington, Wisconsin, and West Virginia. Notice North Dakota, North Carolina, those weren't listed, only the South ones. That's kind of interesting. They don't have specific rules for e-discovery as of the writing of our text, though I believe many of these states actually have current legislation in the works. Internal corporate investigations usually fall into the civil category, not criminal. So search warrants aren't necessary. Most companies have policies specifying that when a complaint is filed, the internal investigation occurs. If a criminal activity is discovered during the investigation, corporate legal counsel is notified, and then the authorities thereafter, and then from there decide what should occur. Alright, moving on. E-discovery from a civil perspective. Civil e-discovery bypasses many search warrant procedures required in a criminal case. Lawyers on both sides are involved from the beginning. Two cases that cause the court system to take a look at the court's burden of e-discovery. Zoomblock case and Rowe Entertainment versus the William Morris Agency. They're the two of the cases that looked at the cost of e-discovery. Courts developed a test consisting of 7 factors to determine the costs, determine if the costs are shifting. They are the extent to which a request is tailored to the discovery relevant information, the availability of information from other sources, the total cost of production compared with the amount of controversy, the total cost of production compared with the resources available each party's ability and incentive to control the costs, the importance of issues at stake in the litigation, and lastly, the benefit to both parties of obtaining the information. Those are the 7 key figures. Alright, so how do we read a case? How do we analyze a case? Challenges for IT personnel involved in e-discovery is reading case law. IT personnel need to understand how to read a case and to determine the appropriate information. Law students use a basic tool called IARC for reading, analyzing, and writing legal cases. This book uses a modification of IARC called FIARC. Stands for Fact, Issues, Rules, References, Analysis, and Conclusion. So we add in facts. When reading or reviewing a case, use a word processor to highlight features. Basically, we want to make sure that we understand we can highlight stuff. Find important items so that we can find them again later. Highlight them. Examples. Facts could be highlighted in green. Conclusions could be highlighted in a different color. And then use a a key so that you know what green means, what red means, what yellow means, so you can quickly reference them later. Fact, issues, rules and references, analysis, conclusion. Determine the actual facts. What are the issues resulting from the case? What rules and what were the references? What analysis was applied to the facts, issues, and rules presented? And what conclusion? We have what's called the Electronic Discovery Reference Model, EDRM. Often, it's objective. It shrinks huge amounts of data down to a more manageable scale. It was created by a team of 2 individuals in 2005, George and Tom. It serves as a roadmap for handling overwhelming amounts of e-evidence in a civil case. It's very widely used in businesses. It's useful in reducing the volume of information to what is relevant. It has 9 stages: information management, identification, preservation, collection, process, review, analysis, production, presentation. Some of the stages overlap or take place simultaneously. For example, collection and preservation are done in loops. These 2 tasks are repetitive processes. The processing, review, and the analysis are all done in loops also. Looking at the next figure, we can see that. Manage information, identification, preservation, collect, and that will go into the processing, review, the analysis, and they'll loop until production, then presentation. Information management is how a company organizes and manages the data. Information governance is a way to ensure that data is managed correctly. During the development of the EDRM model, participants decided information management needed its own model. Information governance reference model, IGRM, was the byproduct of that. Governance plays a huge role in governing, in protecting, in verifying that we are doing what we're supposed to be doing, and it's done correctly. Here is the IGRM model. The IGRM model reflects the common lack of communication and collaboration in dealing with information management. Shows each group's effect on the process. The three main groups are business users, legal, regulatory, risk management, compliance, and the third group is the support staff. Privacy and security have recently been added because they are growing as a concern. The EDRM has identified stages that start with identifying potential sources of relevant data. The team sets up the requirements for what's to be collected. The preservation and collection stages are interwoven. They are working hand in hand. The duty to preserve is a provision of the FRCP stating that the company must retain all documents and data pertaining to the case. The collection stage relies on the requirements developed in the identification stage. The stages build on themselves. You can look at them individually, but they are as a whole. Okay, the purpose of these stages, the processing stage has four of the subtasks. Things like assessment or duplication, or duping. Duping occurs when multiple people have received the same email and software is used to compare the email identifiers across all of them. Multiple custodians. A custodian is those responsible for granting access to files or emails. Preparation. This includes the restoring, backup, converting, file types, full text indexing, and other procedures. The selection process, which reduces the amount of data that will be sent to the opposing counsel. And output, which is converting data into the required formats. So there is a very specific structure to the EDMR model. Review stage is the investigators take into account what's relevant and what's considered not, whether to exclude the proprietary information, such as trade secrets, confidential government information, or other secretive information that may be redacted. We have the analysis stage, which investigators examine the files for relevant information, patterns, keys, terms, people's names, personal identifiable information, PII, or health records maybe. We have the production stage, which packages data and puts it into a format both sides have agreed on. And then lastly, we have the presentation stage. And this occurs if there is a conflict. The EDRM processes is different in criminal cases. This is because it usually relies on surveillance and other secretive tasks at various stages. Instead of record records, managers or IT staff, law enforcement identifies, preserves, and collects the discovery, not managers, not IT staff. So in civil litigation, burden of finding evidence is on the requesting party. In a criminal case, after the case has been filed, law requires the prosecution disclose evidence to the defendants, even if it's not requested. Three main legal directives that will influence the disclosure of criminal discovery: the Brady Doctrine, the Genix Act, and the, I don't know how to pronounce that, the Gigolo versus U.S. prosecution. They are all dealing with disclosures. The Brady Doctrine is prosecution is required to disclose all exculpatory evidence to the defense team. The other two deal with prosecution is required to disclose all witness impeachment information to the defense team. In most cases, prosecution also requests a review of the defense team's evidence and experts or witness information. Okay, so this slide more focuses on understanding that we're using this as a text in a class. This case study is used throughout this book and allows us to practice techniques in real-world settings. We're going to be looking at a landmark case surrounding the Enron bankruptcy. So, before the scandal, October 2001, Enron was the largest seller of natural gas. Enron executives were allowed to maintain agencies over earning reports sent to investors. Those executives did not have to report losses to their own, or did not have to report losses or their own financial statements. So this is why they were able to present a profitable public image while pocketing the profits. Investors lost over $70 billion. Enron filed Chapter 11 bankruptcy in 2001 in December, so 2 months later. Enron was investigated by the Securities and Exchange Commission's SEC, and in November 2001, falsified earnings, hidden losses, and embezzlement were uncovered. The accounting and auditing firm Arthur Andersen was charged with obstruction of justice as they destroyed documents related to its audit of Enron. Because of that, we have SOX. And this was passed as a direct result of corporate scandals such as Enron. Major players in Enron scandal, the accounting firm. Other big ones are the former Enron Chief Financial Officer, Andrew Fastow, an alleged creator of the deceptive accounting practice. They were fired when the scandal unfolded. Kenneth Lay, which was Enron's former chief executive and chairman since '86. He also refused to testify. David Ducon, which is Andersen's chief auditor, shredded key documents related to the case. Joseph Bernardino, Andersen's chief executive, and defended his firm's role in the affair. Other major players were Jeffrey Skillings, Enron's chief executive in the first half of 2001, denied knowing anything was wrong. Sharon Watkins, which is Enron's employee who was the whistleblower of the scandal, claimed Ken Lay was duped. Placed blame on Jeffrey Skillings and Andrew Fastow. This is where it gets really interesting. More than 300,000 emails were part of the evidence used in court. A challenge of e-discovery is narrowing down the search parameters to prevent sifting through the terabytes of data. 300,000 emails, that's a lot. And that's just what was as part of the evidence. That wasn't all of the data. That was not all of the emails. That was just a portion of the emails that were used. The purpose of using the well-known case is to make you more aware of a few very important points. Understanding the volume of emails, the steps that were involved, how duping works, and how to figure out what's relevant and what's not. And that is Chapter 2 in a nutshell. If you have any questions, please let me know. Thank you.